I was halfway through my morning coffee when I saw the certified letter from the Riverside Estates Homeowners Association claiming I owed them $43,000 in back dues, spanning 20 years. My hands shook as I read the threat of a lien on my property in Phoenix, Arizona, if I didn't pay within 30 days. The problem was simple and infuriating. I wasn't in their HOA. I had never been in their HOA. My house at 4782 Sagaro Drive had been carefully chosen specifically because it wasn't part of any homeowners association. I remembered the exact moment 5 years ago when my real estate agent assured me that this property was HOA-free, and I remembered the relief I felt signing those papers. I'm Richard Lawson, a 42-year-old software engineer who works from home. I bought this modest 3-bedroom ranch house in 2021 because I wanted peace and quiet without someone telling me what color I could paint my mailbox. The neighborhood was nice enough, with the Riverside Estates HOA community situated about 2 blocks south of my street. But my section of older homes had been built in the 70s, decades before any HOA existed in the area. I grabbed my deed from the filing cabinet in my home office. The document was clear as day. No mention of any HOA, no covenants, conditions, or restrictions attached. Nothing that bound me to any neighborhood association whatsoever. My attorney had reviewed everything during closing, and we had specifically verified the absence of HOA entanglements. The letter was signed by someone named Patricia Drummond, HOA president. It included a breakdown of alleged unpaid dues starting from 2006, which was bizarre considering I only bought the house in 2021. The math showed $215 per month, every month, for 240 months. Late fees and interest had ballooned the total to that astronomical $43,000 figure. I called the number listed on the letterhead immediately. A woman with a sharp nasal voice answered on the third ring. Riverside Estates HOA, this is Patricia speaking. Hi, my name is Richard Lawson. I just received a letter claiming I owe your HOA $43,000. There's been a serious mistake. Let me pull up your account. Address: 4782 Sagaro Drive. I heard typing on a keyboard, then a long pause. Yes, Mr. Lawson. Our records show that property has been in violation of payment requirements since 2006. The previous owner also failed to pay, and those debts transfer with the property. That's impossible, I said, keeping my voice level. My property isn't part of your HOA. I have my deed right here, and there's no mention of any homeowners association. Our boundaries include all properties on Sagaro Drive, Patricia said with absolute certainty. Your deed doesn't change our established community borders. Then your boundaries are wrong. I specifically bought this house because it wasn't in an HOA. Sir, I understand you're upset, but the facts are the facts. You need to pay this amount, or we'll be forced to place a lien on your property. We've been more than patient. My jaw clenched. I'm not paying a single cent to an organization I don't belong to. You need to correct your records. I'll be sending this matter to our attorney if payment isn't received within 30 days. Have a good day, Mr. Lawson. She hung up before I could respond. I spent the next hour searching through every document related to my house purchase. The deed was unambiguous. The title insurance policy made no mention of an HOA. The closing disclosure listed no HOA transfer fees or dues. My title search had come back clean. Every piece of evidence supported what I already knew. I wasn't part of Riverside Estates, HOA. But I also knew that HOAs could be relentless, and an improper lien on my property could cause serious problems if I ever wanted to refinance or sell. I needed to handle this properly. I called my real estate attorney, David Chen, who had handled my closing. His paralegal put me through after a brief hold. "Richard, good to hear from you. What's going on?" I explained the situation, reading portions of the letter aloud. "That's absurd," David said. "I personally verified your property's HOA status during the title search. You're definitely not part of Riverside Estates. You still have your deed right in front of me. Okay, here's what we're going to do. I'll draft a letter to this Patricia Drummond explaining that her claim is baseless and that any attempt to place a lien will be met with immediate legal action. I'll cite the relevant Arizona property laws. This should be enough to make them back off. What if it's not? Then we sue them for harassment and any damages. But honestly, once they see official pushback from an attorney, these things usually disappear. HOAs overreach constantly, but they typically retreat when confronted with actual legal opposition. What's this going to cost me? I'll bill you for 2 hours to draft the letter and handle any immediate follow-up. If it escalates beyond that, we'll discuss it. Should be around $600. It annoyed me to spend money fighting a completely fraudulent claim, but I didn't have much choice. Do it. Send me the letter before it goes out so I can review it. Will do. I'll have something to you by tomorrow afternoon. I thanked him and hung up, feeling slightly better but still irritated. This was exactly the kind of bureaucratic nonsense I tried to avoid by buying outside an HOA. The next day, David emailed me a strongly worded letter on his law firm's letterhead. It cited Arizona Revised Statutes Title 33, Chapter 16, explaining that HOA authority only extends to properties explicitly bound by recorded CC and Artiques, which my property was not. The letter demanded that Riverside Estates immediately remove my property from their records and cease all collection efforts. It warned that continued harassment would result in legal action for damages, including attorney fees. "Perfect," I wrote back. "Send it." "Already in the mail, certified return receipt," David replied. I thought that would be the end of it. 3 days later, I received another letter from Riverside Estates. This time it was from their attorney, a firm called Morrison and Associates in Scottsdale. The letter repeated the same claims about unpaid dues and stated that because I had refused to cooperate, they were proceeding with a lien. They gave me 14 days to pay before filing. I immediately forwarded the letter to David. He called me within an hour, and he sounded genuinely angry. "This is incredible. They're completely ignoring the legal facts. Their attorney should know better than to pursue this." "So what now?" "Now we file a declaratory judgment action. We go to court and get a judge to officially declare that your property is not subject to their HOA. It'll cost more than I initially quoted, but if we win, Arizona law allows us to recover our attorney fees from them." "How much are we talking?" "Could be anywhere from $5,000 to $10,000 depending on how far they push this. But again, if the judge rules in our favor, which I'm confident will happen, they'll have to pay it all. You'd be out of pocket until then, though." I thought about it for maybe 10 seconds. I wasn't wealthy, but I had savings. More importantly, I wasn't going to let some power-hungry HOA board bully me into paying for something I didn't know. Let's do it. File the lawsuit. I'll get the complaint drafted and filed this week. In the meantime, don't communicate with them directly. All contact goes through me now. Understood. David filed the declaratory judgment action in Maricopa County Superior Court 3 days later. The complaint was straightforward. It asked the court to declare that my property at 4782 Saguaro Drive was not and had never been subject to the Riverside Estates HOA, and it requested that the court order the HOA to cease all collection efforts and pay our attorney fees. The HOA had 20 days to respond. During that waiting period, things escalated in ways I didn't expect. I came home from the grocery store on a Saturday afternoon to find Patricia Drummond standing in my driveway with two other middle-aged women. Patricia was exactly what I'd imagined based on her voice. Late 50s, severely cut blonde hair, wearing an expensive-looking cream pantsuit despite the Arizona heat. The other two women flanked her like bodyguards. "Can I help you?" I asked, getting out of my car with grocery bags in hand. "Mr. Lawson, I'm Patricia Drummond, HOA president. We need to discuss your delinquent account. My attorney told you to direct all communication through him. This is community business. We're trying to resolve this amicably before it gets more expensive for everyone." I set my groceries on the hood of my car. "There's nothing to resolve. I'm not part of your HOA. The court will confirm that." "Your property is within our boundaries," Patricia insisted. "Our plat map clearly shows Saguaro Drive included in Riverside Estates." "Then your plat map is wrong. My deed supersedes whatever map you're looking at." One of the other women, a brunette with too much makeup, spoke up. "You're being incredibly selfish. Everyone in this community pays their fair share. You can't just opt out because you feel like it." "I didn't opt out. I was never in." "This property predates your HOA by decades." "That's not what our records show," Patricia said. "We have documentation going back to when Riverside Estates was founded in 1998. Saguaro Drive has always been included." "Show me," I said. "Show me any document with my property address that includes HOA language." Patricia's lips pressed into a thin line. "Our attorney has all relevant documentation. This is your last chance to settle this reasonably. Pay what you owe, and we can work out a payment plan for the late fees." "I'm not paying a cent. If you or anyone from your HOA sets foot on my property again, I'll call the police for trespassing. All communication goes through my attorney. Now please leave." Patricia's face flushed red. "You're making a huge mistake. We have ways of making life difficult for homeowners who don't comply." "Is that a threat?" "It's a fact. Good luck, Mr. Lawson. You're going to need it." The three women turned and walked back down my driveway. I watched them get into a silver Lexus SUV parked on the street and drive away. I immediately called David and told him what happened. "Document everything," he said. "Write down exactly what was said and when. If they show up again, call the police and then call me. This kind of harassment actually helps our case." The HOA's answer to our complaint arrived 2 weeks later. Their attorney argued that the boundaries of Riverside Estates had been properly established and recorded in 1998, and that those boundaries included portions of Saguaro Drive. They claimed that even if my specific deed didn't mention the HOA, the community plat map took precedence, and all properties within the mapped boundaries were subject to HOA authority. It was creative but completely wrong under Arizona law. David filed a motion for summary judgment, arguing that no genuine dispute of material fact existed. My deed contained no HOA language, no CC and Articus were recorded against my property, and therefore the HOA had no authority over my home. He attached my deed, the title insurance policy, and the complete title search as exhibits. The hearing was scheduled for late October, about 6 weeks after the motion was filed. In the meantime, the harassment continued. I started receiving violation notices from the HOA. They claimed my lawn was too long, even though I'd mowed it 3 days earlier. They said my house color violated community standards, despite my house being the same tan shade it had been for decades. They claimed my trash cans were visible from the street, which apparently violated some rule I'd never agreed to follow. Each notice threatened fines of $50 per day until the violation was corrected. I forwarded every notice to David, who added them to our case file. Then things got worse. I woke up one morning in early October to find a bright orange sticker on my front door. It was the size of a sheet of paper and read, HOA violation, delinquent account, property subject to lien. The sticker was designed to be humiliating, visible to anyone walking or driving past my house. I tried to peel it off, but it left a sticky residue that took me 20 minutes and half a bottle of goo gone to remove. I took photos of everything and sent them to David. "This is harassment and possibly defamation," he said when I called. "I'm going to request an emergency hearing to get a restraining order. This has gone too far." The emergency hearing was scheduled for 3 days later. I had to take time off work to appear in court, which added to my frustration. Judge Martha Rodriguez heard our motion in a small courtroom in downtown Phoenix. She was a stern-looking woman in her 60s with gray hair pulled back in a bun. Patricia Drummond was there with the HOA's attorney, a slick-looking man in his 40s named Robert Morrison. David presented the evidence: the violation notices, photos of the sticker, my documentation showing no HOA affiliation, and a timeline of escalating harassment. "Your Honor, Mr. Lawson is being subjected to systematic harassment by an organization that has no legal authority over his property," David argued. "The HOA knows their claim is baseless, which is why they've resorted to intimidation tactics. We're requesting a temporary restraining order preventing any further contact or actions directed at Mr. Lawson's property until the underlying declaratory judgment action is resolved." Morrison stood up. "Your Honor, Riverside Estates HOA is simply attempting to enforce its legitimate rules and collect legitimately owed dues. Mr. Lawson's property falls within our established boundaries, and we have both the right and the obligation to our other homeowners to enforce compliance." Judge Rodriguez looked at Morrison over her reading glasses. "Counselor, has your client recorded any CC and Articus against Mr. Lawson's property specifically? The community CC and Articus apply to all properties within our boundaries, Your Honor." "That's not what I asked." "Are there recorded CC and Articus that specifically encumber the property at 4782 Saguaro Drive?" Morrison hesitated. "The property falls within the plat map boundaries. I'll take that as a no." Judge Rodriguez flipped through the documents in front of her. "Mr. Lawson's deed contains no reference to your HOA. His title search revealed no encumbrances related to your HOA. On what legal basis are you claiming authority over his property?" "The 1998 plat map that established Riverside Estates boundaries, Your Honor." "Those boundaries are on file with the county. A plat map doesn't create a covenant. You know that, Mr. Morrison." The judge's tone was sharp. "I'm granting the temporary restraining order. Riverside Estates HOA and all its agents are prohibited from contacting Mr. Lawson, entering his property, posting any notices on his property, or taking any action against his property until this matter is fully adjudicated. Violation of this order will result in contempt charges. Am I clear?" "Yes, Your Honor," Morrison said quietly. "Good. The summary judgment hearing remains on calendar for October 28th. I suggest your client uses that time to carefully review Arizona property law." We left the courtroom victorious, at least temporarily. The restraining order would keep the HOA off my back until the main hearing. "That went well," David said as we walked to the parking garage. "Judge Rodriguez clearly sees through their nonsense. I'm feeling very good about the summary judgment hearing. Thanks for getting this done so quickly." That's what you pay me for. Try to relax for the next few weeks. They can't touch you now without facing contempt charges. The restraining order worked. The harassment stopped completely. No more violation notices, no more visits to my property, no more threatening letters. But I couldn't quite relax. I kept waiting for the other shoe to drop. The summary judgment hearing arrived on a cool October morning. The temperature in Phoenix had finally dropped below 90 degrees, and there was a hint of actual fall in the air. David and I arrived at the courthouse early. Morrison was already there with Patricia Drummond and another board member, a man in his 60s wearing an expensive suit. We didn't speak to them. The tension in the hallway was thick enough to cut. Judge Rodriguez called our case promptly at 9 o'clock. We took our seats at the respective counsel tables, and the judge dove right in. I've reviewed the moving papers, the opposition, and the reply. Mr. Chen, I'll hear from you first. David stood and presented our argument clearly and concisely. The facts were simple. My property had no recorded CC and Artiques. My deed made no mention of an HOA, and Arizona law required clear, recorded covenants to bind a property to HOA authority. The HOA's plat map was insufficient to create such an obligation. Morrison argued that the community boundaries had been properly established and that my property fell within those boundaries. He kept returning to the 1998 plat map as if it were some kind of trump card. Judge Rodriguez interrupted him mid-sentence. Mr. Morrison, I've looked at your plat map. It shows general neighborhood boundaries, but it doesn't create enforceable covenants against individual properties. Where are the recorded CC and Artiques for 4782 Seguero Drive? Your Honor, the CC and Artiques were recorded in 1998 for the entire Riverside Estates community. But not against this specific property. Correct. Morrison shifted his weight. The property is within the boundaries. That's not sufficient under Arizona law, and you know it. Title 33, Chapter 16 is very clear about this. A property must have recorded covenants specifically encumbering it for HOA authority to attach. Being near an HOA or even within some theoretical boundary line isn't enough. Your Honor, we've been treating this property as part of the community for decades. Incorrectly treating it, Judge Rodriguez said. Let me ask you something, Mr. Morrison. Did you actually review the title records for this property before pursuing this claim? There was a long pause. Morrison glanced at Patricia, who was staring straight ahead with a frozen expression. We relied on our community records, Morrison finally said. In other words, no, you didn't do basic due diligence before demanding $43,000 and threatening a lien. The judge shook her head. This is exactly the kind of HOA overreach that wastes everyone's time and money. Mr. Chen, your motion for summary judgment is granted. The court declares that the property located at 4782 Seguero Drive, Phoenix, Arizona, is not subject to the Riverside Estates Homeowners Association and never has been. The HOA is ordered to immediately remove this property from its records and cease all collection efforts. As for attorney fees, I'm awarding those to Mr. Lawson as well. Mr. Chen, submit a detailed accounting of your fees and costs within 14 days. Thank you, Your Honor, David said, trying to contain his smile. Mr. Morrison, I strongly suggest you advise your client to be more careful in the future. Attempting to collect tens of thousands of dollars without verifying basic legal facts borders on bad faith. You're fortunate I'm not sanctioning you personally. This matter is concluded. The gavel came down, and it was over. We won. Patricia's face had gone from red to pale white during the judge's remarks. She stood up stiffly and walked out of the courtroom without looking at anyone. The other board member followed her, whispering urgently. David and I waited until they'd left before celebrating in the hallway. "That was about as decisive as victories get," David said. "Judge Rodriguez completely eviscerated their case. Now we just need to calculate fees and get you reimbursed." "How much do you think it'll be?" "I've logged about 42 hours on this matter so far at $300 per hour, plus filing fees, service costs, and other expenses, probably around $14,000 total." I let out a low whistle. "And they have to pay all of it, every cent." Arizona law is very favorable to homeowners in cases like this. When an HOA wrongfully pursues collection or enforcement, they're liable for the homeowner's legal defense. It's meant to discourage exactly this kind of behavior. We shook hands in the parking garage, and I drove home feeling lighter than I had in months. The nightmare was finally over, or so I thought. David submitted his fee petition 2 weeks later. It detailed every hour spent, every document filed, every court appearance. The total came to $14,372. The HOA had 30 days to pay. 30 days came and went. No payment. David filed a motion to enforce the judgment. Judge Rodriguez held another brief hearing and ordered Riverside Estates HOA to pay within 10 days or face daily penalties. 10 days passed. Still no payment. "They're playing games," David told me over the phone. "Some HOAs do this, hoping you'll just give up or settle for less. But we're not going to do that. I'm going to start garnishment proceedings against their bank accounts." "Can you do that?" "Absolutely. A judgment is a judgment. If they won't pay voluntarily, we'll take it involuntarily." David filed the garnishment paperwork. This required discovering which bank the HOA used and serving the bank with an order to freeze funds and turn them over to satisfy the judgment. This process took several more weeks, but eventually, David's investigator found that Riverside Estates HOA banked with Chase. We served the garnishment order, and Chase froze the HOA's operating account pending resolution. That finally got their attention. Morrison called David directly, asking to negotiate a payment plan. David's response was simple: full payment within 48 hours or the garnishment stands. They paid. The check arrived at David's office on a Friday afternoon in early December. $14,372, plus an additional $3,000 in penalties for their delay in paying. David deposited the check, confirmed it cleared, and then cut me a refund check for the $600 I'd paid upfront and the $3,000 in penalties. "The penalties are yours under the judgment," David explained. "Congratulations. You not only won, but you came out ahead." I stared at the check. After all the stress and frustration, the HOA had ended up paying me to defend myself against their baseless claim. "This feels like justice," I said. "It is justice. That's what the system is supposed to do." I thought the story would end there. I'd won my case, recovered all my costs, and even made a small profit. The HOA couldn't bother me anymore without facing serious consequences, but the universe apparently had one more chapter to write. In mid-December, I received a call from a detective with the Phoenix Police Department. His name was Detective James Warren, and he asked if he could come by my house to discuss Riverside Estates HOA. "Am I in some kind of trouble?" I asked, confused. "No, sir. You're not in any trouble. We're investigating the HOA and your name came up in our inquiry. I'd like to ask you some questions about your experience with them." He arrived an hour later, a tall black man in his 40s wearing a blazer and tie despite the casual nature of a home visit. I offered him coffee, which he accepted, and we sat at my kitchen table. "Mr. Lawson, I want to start by thanking you for your time. I understand you recently won a lawsuit against Riverside Estates HOA. That's right. They claimed I owed them 20 years of back dues even though my property was never part of their HOA. Can you tell me everything that happened? Start from the beginning. I walked him through the entire timeline. The initial demand letter, my research into my deed, hiring David, the harassment, the restraining order, the court victory, and finally getting paid. Detective Warren took detailed notes. When I finished, he sat back and sipped his coffee thoughtfully. Mr. Lawson, you're the 7th person who's contacted us with similar complaints about Riverside Estates HOA. The pattern is almost identical in each case. Patricia Drummond and the board claim a property owes substantial back dues. They threaten liens, they harass homeowners, and they ignore evidence that the property isn't actually in the HOA. 7 people. That's insane. It gets worse. 3 of those people paid. They paid thousands of dollars each because they were scared of losing their homes. They didn't have the resources to fight it in court like you did. A cold anger settled in my stomach. She's running a scam. That's what we're investigating. The problem is proving criminal intent. Drummond and her attorney could argue they genuinely believed these properties were in the HOA, that it was an honest mistake in their record keeping. But 7 properties, 7 mistakes. I agree it strains credulity. That's why I'm here. I'm trying to build a case. Can you provide copies of all your documentation? The demand letters, violation notices, everything? Absolutely. I have everything organized. I went to my office and returned with a thick folder containing every document related to the case. Detective Warren flipped through them, stopping occasionally to photograph specific pages with his phone. This is excellent. The violation notices after you'd already filed suit are particularly damning, shows consciousness of wrongdoing. He closed the folder. Would you be willing to testify if we bring charges? Without hesitation. If she's scamming people, she needs to be stopped. I appreciate that. Let me give you my card. If you remember anything else or if they contact you again, call me immediately. We shook hands and he left. I sat at my kitchen table for a long time afterward, thinking about those 3 people who'd paid. How much had Patricia Drummond stolen from them? How had she identified targets? The more I thought about it, the angrier I became. Over the next several weeks, Detective Warren kept me updated on the investigation. He'd subpoenaed the HOA's financial records and found some troubling patterns. Money that came in from these disputed back dues didn't always make it into the HOA's main operating accounts. Some of it had been redirected to accounts controlled personally by Patricia Drummond. She's been embezzling, Detective Warren told me over the phone in January. We found nearly $90,000 that she collected from homeowners and kept for herself. She'd record it as paid in the HOA books, but then divert the actual money to her personal accounts. The board members had no idea. Holy shit. We're bringing charges next week. Fraud, theft, extortion. She's looking at serious prison time if convicted. Good. The arrest happened on a Tuesday morning. I didn't witness it, but it made the local news. Patricia Drummond, 58, HOA president of Riverside Estates, arrested on multiple felony charges related to fraud and embezzlement. The news segment showed her being led out of her expensive house in handcuffs, her face hidden behind her hands. The story grew bigger as more victims came forward. By the time the initial investigation concluded, prosecutors had identified 11 separate homeowners who'd been targeted by Drummond's scheme. 8 had paid a combined total of $137,000. 3 of us had fought back successfully. Drummond's attorney, Robert Morrison, was also under investigation for his role. Prosecutors were trying to determine whether he'd knowingly participated in the fraud or had simply been negligent in his due diligence. Either way, his reputation was destroyed. Several former clients filed bar complaints, and his firm dissolved within months. The criminal trial took place the following summer. I was called to testify about my experience. The courtroom was packed with other victims and their families. I told the jury about receiving the initial demand letter, about Patricia showing up at my house with threats, about the harassment campaign, and about the orange sticker on my door. The prosecutor displayed blown-up photos of the violation notices and the sticker on large monitors. Mr. Lawson, at any point did Miss Drummond ever provide proof that your property was actually in the HOA? The prosecutor asked. Never. She just kept insisting it was, despite all evidence to the contrary. And how did this experience make you feel? Violated, stressed, angry? I'd specifically bought my house to avoid HOA problems, and here was someone trying to extort $43,000 from me based on completely false claims. The defense attorney, a woman named Sarah Collins, cross-examined me. Mr. Lawson, isn't it possible that Miss Drummond genuinely believed your property was part of the HOA, that this was an honest mistake? If it was one property, maybe, but 11. And when I proved my property wasn't in the HOA, she didn't back down. She escalated. She harassed me. That's not someone making an honest mistake. But you can't know what was in her mind. I know she tried to collect $43,000 from me without any legal basis. I know she violated a court restraining order. I know she embezzled money from actual HOA members. Those aren't the actions of someone making innocent mistakes. Collins moved on, but I could tell the jury wasn't buying her defense strategy. Other victims testified over the following days. An elderly widow named Margaret who'd paid $15,000 because she was terrified of losing her home. A young couple who'd scraped together $8,000 from their savings. A small business owner who'd paid $12,000 just to make the harassment stop. Each story was heartbreaking. Each story showed the same pattern of intimidation and fraud. The financial evidence was damning too. Forensic accountants testified about the money trail, showing exactly how Drummond had diverted funds to her personal accounts. She'd used the stolen money to pay for luxury vacations, expensive jewelry, and home renovations. The jury deliberated for less than 4 hours. Guilty on all counts: fraud, theft, extortion, and embezzlement. 15 felony counts in total. At sentencing 2 months later, Judge Rodriguez, the same judge who'd heard my civil case, gave Patricia Drummond 8 years in state prison and ordered her to pay full restitution to all victims. Her face crumpled as the marshals led her away in handcuffs. The other board members of Riverside Estates, HOA, were not charged. The investigation found they'd been genuinely unaware of Drummond's activities. She'd controlled the records and bank accounts with little oversight, a common problem in HOA governance. The HOA itself was effectively disbanded after the scandal. Property values in the actual Riverside Estates community plummeted, and many homeowners sued to dissolve the association entirely. They succeeded in early 2027. As for Robert Morrison, he was never criminally charged, but the Arizona State Bar suspended his license for 2 years due to negligence and failure to conduct proper due diligence. His legal career never recovered. I followed all of this from the sidelines, grateful that I'd stood my ground and fought back. If I'd been intimidated into paying, Drummond would still be running her scam, and more people would have been victimized. On a warm evening in late September 2027, about 2 years after receiving that first threatening letter, I sat on my back patio with a beer and looked out at my yard. My lawn was whatever length I wanted it to be. My trash can sat visibly by my garage. My house was painted the same tan color it had always been. No one could tell me otherwise because my deed was clear. The court had confirmed it, and the person who tried to claim power over my property was in prison. David Chen had become a good friend through the ordeal. We got together every few months for drinks and dinner. At one of these gatherings, about 3 years after everything concluded, he told me something interesting. You know, the Lawson case became something we teach at the law school now. I was invited to give a guest lecture at ASU about HOA overreach and property rights. Your story is the centerpiece. Really, really. It's a perfect example of why homeowners need to understand their property rights and not be intimidated by organizations claiming authority they don't actually have. And it's a cautionary tale for attorneys to do their due diligence before filing aggressive collection actions. I'm glad something good came from all that stress. More than you know. After your case got publicity, 3 different bills were introduced in the state legislature to reform HOA governance and increase oversight. 2 of them passed. HOAs now have to verify property inclusion before pursuing collection actions, and there are significant penalties for fraudulent claims. I raised my beer. To standing your ground. David clinked his glass against mine. To standing your ground. The restitution money from Patricia Drummond's criminal case came through in installments over several years as the court seized and liquidated her assets. I received my full $3,000 in penalties, plus additional compensation for emotional distress. Other victims who'd actually paid her received their money back with interest. Margaret, the elderly widow, used her restitution to finally take the European vacation she'd always dreamed of. She sent me a postcard from Paris thanking me for testifying. "Justice matters," she wrote in shaky handwriting. "Thank you for fighting." The young couple bought a different house, this time with David Chen's help to ensure no HOA entanglements. They sent me a Christmas card every year with photos of their growing family. As for me, life returned to normal. I continued working from home, enjoying my HOA-free existence. I could park my car anywhere in my driveway, paint my door whatever color I wanted, and plant whatever I felt like in my yard. These small freedoms meant more to me after nearly losing them to a fraudulent claim. I also became something of an accidental activist. Other homeowners dealing with HOA disputes reached out to me for advice. I always told them the same thing. Document everything, know your rights, read your deed, and don't be afraid to fight back if you're in the right. Many of them went on to win their own cases. Detective Warren and I stayed in touch too. He'd moved on to other cases, but the Drummond investigation remained one of his most satisfying. "It's rare that we get such a clear-cut case of fraud with such a positive outcome," he told me. "Usually these things are murky, but you kept perfect records and that made all the difference." The one weird footnote to the whole story came about 4 years later, in 2029. I received a letter from Patricia Drummond, forwarded through the prison system. David advised me not to read it, but curiosity got the better of me. The letter was 3 pages of small, cramped handwriting. She claimed she'd been trying to serve the community, that she'd gotten in over her head with personal debts, that she'd never meant to hurt anyone. She didn't quite apologize, but she asked for forgiveness and understanding. I read it twice and then threw it away. Some people never take full responsibility for their actions. Drummond had systematically defrauded 11 families, stolen over $130,000 and caused immeasurable stress and harm. Her excuses didn't change that, but I didn't dwell on it. The justice system had worked. The victims had been made whole. The law had been clarified to prevent similar abuses. That was as close to a happy ending as real life provides. My house at 4782 Sagaro Drive remained my sanctuary, my HOA-free zone, my small piece of the American dream where no one could tell me how to live. Every time I pulled into my driveway, I felt a little spark of satisfaction knowing I'd fought for that freedom and won. The local news did a follow-up story 5 years after Drummond's arrest. They interviewed several victims, including me, about life after the scandal. The reporter, a young woman named Jessica Andrews, asked me what I'd learned from the experience. "I learned that knowing your rights is crucial," I said. "I learned that documentation is everything. I learned that standing up to bullies, even when it's expensive and stressful, is worth it. And I learned that most people are good. My attorney fought for me. The detective investigated thoroughly. The judge ruled fairly. The system worked like it's supposed to." Would you do anything differently if you could go back? I thought about that for a moment. I would have called a lawyer even sooner. The moment I got that first letter, I should have had legal advice. It would have saved some stress. But overall, no. I did what I needed to do. The story aired during the evening news and got picked up by several national outlets. I received dozens of messages from people around the country dealing with similar HOA nightmares. I tried to respond to as many as I could, offering encouragement and practical advice. One message stuck with me. It was from a man in Florida named Tom who was fighting his HOA over a disputed property line. "Your story gave me hope," he wrote. "I was about to give up and just pay them, but after seeing what you went through and how you won, I'm going to keep fighting. Thank you." Tom ended up winning his case too. He sent me a bottle of good bourbon when it was all over. These connections, these ripple effects of standing up for what's right, became one of the unexpected blessings of the whole terrible ordeal. I'd never set out to be any kind of advocate or example. I just wanted to live peacefully in my house. But sometimes circumstances push you into roles you never imagined. David's law practice thrived after the Drummond case. He became known as the go-to attorney for HOA disputes in the Phoenix area. His firm grew from just him and a paralegal to a team of 6 attorneys specializing in property and HOA law. He credited my case with launching that expansion. "You were the perfect client," he told me once. "You documented everything, you were reasonable, you trusted the process, and you were willing to fight. That made my job easy and the outcome inevitable. I just didn't want to pay for something I didn't know." That simple principle, standing up for what's right, is surprisingly rare. Most people cave under pressure. You didn't. I never thought of myself as particularly brave or principled. I was just stubborn and annoyed. But I suppose sometimes stubborn annoyance is enough to change things for the better. The Riverside Estates community itself eventually recovered. After the HOA dissolved, the remaining homeowners formed a much smaller, voluntary neighborhood association focused on organizing social events and maintaining common areas through voluntary contributions. No mandatory dues, no enforcement powers, no liens. Just neighbors helping neighbors. Several people from that community reached out to thank me over the years. By exposing Drummond's fraud, I'd inadvertently freed them from a corrupt and poorly run HOA. Property values rebounded, and the neighborhood became known as a desirable place to live precisely because it didn't have traditional HOA restrictions. It's funny how things work out sometimes. As I write this, it's now 2030 and 9 years have passed since I first bought my house. I'm still here at 4782 Sagaro Drive, still working from home, still enjoying my freedom from HOA tyranny. My yard looks however I want it to look. My house is maintained to my standards, not someone else's arbitrary rules. I've thought many times about what would have happened if I just paid that initial demand. $43,000 would have devastated my savings. I would have been paying for something I didn't owe, reinforcing Drummond's fraud and enabling her to victimize more people. By fighting back, I protected not just myself but everyone who came after. That's the lesson I try to share when people ask about my experience. Your rights matter. Documentation matters. Due diligence matters. And sometimes the right thing to do is also the hard thing, but that doesn't make it any less right. The legal reforms that came out of the Drummond scandal made a real difference across Arizona. HOA fraud cases dropped significantly after the new laws took effect. The requirement that HOAs verify property inclusion before pursuing collection has prevented countless situations like mine from ever developing. Judge Rodriguez retired in 2028, and I attended her retirement ceremony. She'd spent 30 years on the bench, and the Drummond case was one of many where she'd stood up for individual rights against institutional overreach. In her retirement speech, she mentioned my case specifically. "Too often, people with power abuse it," she said. "And too often, regular people feel powerless to fight back. But the law is meant to protect everyone equally." When Richard Lawson walked into my courtroom, he had nothing but the truth and his deed. That was enough. That should always be enough. I shook her hand afterward and thanked her for her service. She smiled and said, "You did the hard part. You stood up. I just applied the law." Patricia Drummond was released from prison in 2033 after serving 6 years of her 8-year sentence with time off for good behavior. I heard she moved to Nevada and worked in retail. She was prohibited from serving in any HOA governance role for the rest of her life as part of her probation conditions. I have no desire to ever speak to her or hear from her again. That chapter is closed. Looking back now, I can see the whole experience as a strange gift, though I certainly didn't feel that way while going through it. It taught me about the law, about standing up for myself, about the importance of community and having good people like David Chen in your corner. It connected me with other people fighting similar battles. It led to real reforms that helped others. None of that would have happened if I just quietly paid that fraudulent bill. My advice to anyone facing something similar is simple. Know your rights. Read your deed. Don't be intimidated by official-looking letters or threats. Document everything. Find a good lawyer. And fight if you're in the right. The system isn't perfect, but it can work. Justice can prevail. Sometimes it takes time and money and stress, but the alternative, letting fraud and abuse go unchallenged, is worse. I still live at 4782 Seguero Drive. It's still not part of any HOA. My deed still clearly states that fact. And every morning when I make my coffee and look out at my yard, I feel grateful that I fought to protect it. Some battles are worth fighting. Some principles are worth defending. And sometimes a simple truth, backed by documentation and determination, really is enough to win against those who would abuse their power. That's my story. That's how the HOA claimed I owed 20 years of dues, how my deed proved I was never in the HOA, and how they ended up paying my lawyer. It's a story about standing your ground, about knowing your rights, and about the importance of fighting back against fraud and intimidation. And it's a reminder that home ownership means something. That piece of paper, that deed in my filing cabinet, represents more than just property. It represents freedom, autonomy, and the right to live your life on your own terms. No one gets to take that away without a fight, not even an HOA president with an overinflated sense of authority and a criminal scheme. I won. The law won. And everyone who stands up for their rights after hearing this story continues that victory. That's enough for me.